Hi, Lewis.
Hello, hello.
We've got you here. Thank you, audience members, for bearing with us. Few technical difficulties, but we're all here and your sound sounds good. So let's get started.
Fantastic. Thank you for having me.
Welcome, everyone, to Crypto Defined for February 23rd, 2023. My name is Kathy Chu. I'm a former Wall Street Journal and USA Today reporter. I'm now reporting for TruthDAO, a new journalism organization within a DAO. We aim to be unbiased, nonpartisan. Please visit us at truthdao.xyz. Join our Discord and our Telegram communities. The series is called Crypto Defined. And we have today Lewis Cohen, the co-founder of DLX Law. It's a law firm focused on blockchain and crypto issues. Mr. Cohen was a partner at top law firms focusing on securitization and complex structured financings before starting his own practice after 20 years in the industry. He's been named one of the top 3 ranked lawyers in the blockchain space in the US by Chambers and Partners, and recently led the research and writing of a 180-page paper dealing with whether fungible crypto assets are considered securities. His answer to that, in short, is no. Now, the reason why it's an important time to have Lewis Cohen on is, as many of you in the audience probably will know, the U.S. Securities and Exchange Commission lately has turned its attention to the $1 trillion crypto industry. They have launched a series of lawsuits and cases against the crypto industry. Chair Gary Gensler has said very plainly that he believes most tokens are indeed securities, and this will weigh heavily upon the industry in the next few months. So thank you, Lewis, so much for being here today. We really appreciate your insight and your time in shedding light on this important matter. Lewis,
Thank you for having me, Kathy. It's really a pleasure.
You're welcome. So before we get into the nitty-gritty of regulation, I wanted to start with something you recently tweeted. You wrote, you basically urge in a Twitter thread, you urge people in the crypto community and I guess the general public to be very balanced as they're looking at the crypto industry. You questioned whether crypto is either, quote, a brilliant gift or, quote, a worthless idea. So talk to me a little bit about your view in general, because I think it gives people perspective on where you're coming from and any potential biases you may have.
Yeah, thank you, Kathy. And the tweet was motivated by conversations I've had with people who are both vehement supporters of crypto and harsh critics. And I think it's really important, whichever side of the line you're on, to really take a moment, step back, and ask yourself, what's going on here? It's rare that you have a technology that produces such passionate views on either side. You know, when the internet was getting started, and I was around then for better or worse, there were certainly skeptics out there, and who needs email anyway? And, I think we've all seen that Newsweek guy who said it was never going to amount to anything, and people love newspapers. But nobody hated the internet, with a passion. And people do hate crypto. People are really upset about what's transpired. There's been a lot of bad actors. There are a lot of concerns. There are people who feel that it's really just smoke and mirrors here. It's an append-only ledger. What's such a big deal about that? And it really stirs up strong feelings. And likewise, of course, among supporters, people feel really passionately about it and concerned about what they see the government doing and other, already sort of entrenched actors doing to potentially prevent this new technology from taking hold. And so really what I tried to do, Kathy, was ask people on both sides to step back for a second and listen a little bit to the other side.
So Lewis, where do you fall in the spectrum? Because obviously you advise companies on blockchain and crypto issues. So for the people who would look at this and say, okay, so he's in the space, he's obviously a crypto supporter, and kind of think of your views, anything you say from then on as, okay, he's a crypto supporter. Talk to me a little bit about that. Could you clarify for people where you fall?
Sure. I have a pretty straightforward answer to that question, which is I think it's an inevitability. And I think, as something that is an inevitability, we are each sort of responsible for figuring out what to do with that inevitability. Once Satoshi, whoever she, he, or they were, put together these pieces and sort of created the Bitcoin protocol, that cast in motion a fundamental change in the way humans relate to each other. There's now were ways of moving value around the world very quickly, and most importantly, permissionlessly. And that, once that's done, it's not, that genie's not going back in the bottle. It's only getting more so. And so, whether one supports it and thinks nothing better could have happened in the world than this, or dreads it and thinks what a terrible thing we humans have done to ourselves, I don't know. But I can tell you it's going to be here for a while. It's going to be here, more or less forever. And so, as a lawyer, I wanted to be involved and at least be part of shaping the future of crypto, if it's going to be here.
Right. And you have an interesting trajectory working at different firms on securitization and then kind of moving into this crypto world because you did believe it's an eventuality. So let's talk about the regulatory landscape in the crypto world. As I mentioned in the intro, Chair Gary Gensler has said plainly that he believes most crypto assets are securities. He and other regulators have taken actions such as filing lawsuits against the issuers, pushed some of the actions, pushed Kraken to close its crypto staking operations. And the SEC objected just yesterday to the purchase of bankrupt Voyager's assets by crypto exchange Binance on the premise that some of the reimbursement could be securities. So give us a short overview of how you look at this regulatory push by the SEC, where you think it's headed, Louis, and what it ultimately means for your clients.
Sure. Well, I think it is important to step back and ask oneself, what even is securities law, and why is there such a thing? Because unless you go back to first principles, it's really hard to understand what we're really arguing about, what's at stake here. At the end of the day, raising money from other people is a type of commercial activity that people undertake. We sell things to each other, we provide services to each other, and we provide capital to each other in different ways. The provision of capital, though, has been societally, we've decided, is a very special kind of commercial arrangement, and one where it's very easy for people to be taken advantage of. And as a result, the government, like in so many other areas, has stepped in and said, we need a bit of a level playing field. We need some rules of the road. We need, lanes and speed limits and a variety of other things. And those are our federal securities laws. If you want to raise capital, whether it's equity or debt, you have to follow certain rules. Those are things Congress has passed. We elect representatives. They change the law, but that's the law whether we like it or not. So fair enough. Then you say, well, but Louis, what is securities? What are securities? So if it's a security, we got to regulate it. What is a security? And you could enumerate certain things that probably we'd all agree are securities. Common stock in a company. That's what we mean. That's capital raising. That's, you provide, financing through debt. You provide financing through equity. Those are all securities activity. Those fall within that area of regulation. But Congress, way back in 1933, when they were kind of putting this whole framework together, said, sometimes people are clever. They don't like the idea of being heavily regulated, and they want to sort of do a workaround. And if they want to do a workaround, they're just not going to call it a share of stock or a bond or a note. They're going to come up with some new, different name or some clever little way of getting around all of these regulations. And we don't want that. And so Congress included in the law a kind of catch-all way of a gotcha. So if you're raising money, and you're not calling it equity debt or something like that, but it feels like capital raising that should be regulated, the SEC is the regulator of the space, and courts have a way of saying, I think what you're doing here, even though you haven't called it security, is that you are actually um, functionally doing securities law. And so that idea, which is called an investment contract, has been around for the last 70 years. It's not something that's new with crypto. The thing with crypto is all of a sudden it's caused an intense focus on this, and that I'll pause for a moment to let you follow up, but that's really why we are where we are, because our securities laws are principles based. They're not strict in the sense of if it's a share of stock, it's security. If it's not a share of stock, it's not a security. That's not how they work. And so we look at the economic reality, and in many crypto projects, when you create a new token of some sort or another, when it's first created, the token has no value to speak of. And if you sell it to raise money to sort of create the value, that's a quintessential investment contract. It's not called a security, but it functions like a security. And the SEC has been very clear in pointing that out and saying, hey, you can't do that unless you comply with our laws.
Right.
The catch, as you said, Kathy, is, well, what happens when those tokens get sold and traded? That's when things get interesting.
Well, I think why I was excited to have you on, Lewis, is there's this raging debate. It seems like every day there are 20 news articles about this, about whether this asset is a security, whether LBRY, whether Ether, whether XRP, Kraken's native token, et cetera, and Binance's token, right? FTX's, FTT. So there's this raging debate out there, but what's interesting about what you've done that I haven't quite seen out there is I believe you've actually gone through, you said you've exhaustively reviewed all the case law out there, and that's what led you to author this 180-page report, basically on the subject of, are fungible crypto assets securities? And you and your law firm did this, and your conclusion basically was no. But could you give us a synopsis of this? How long did it take to review all the case law, and why did you ultimately conclude that these are not fungible crypto assets? Fungible means, they are not unique, right?
Yeah.
So fungible crypto assets, why are they not securities? Because this is very important to all the cases going on now.
Yeah, absolutely. Well, in terms of the time it took, it was, we probably worked on it, from the moment there was a gleam in our eye and we got started to when we finished, it was the better part of 3 years. It was immensely time consuming, but really the most intensive work was probably the last 6 to 9 months of putting that all together. Going through all the cases was immensely time consuming, as you might imagine. And that itself probably, because, we are working lawyers, right? So we have a day job. So that probably took over a year.
How many cases did you have to go through?
There's about 260 odd, and we limited ourselves to what we call appellate cases. So when there's a dispute and you first go to court, you go to a trial court in the federal system that's called a district court. One party wins, one party loses. It's possible if for the losing party to appeal and say, hey, could I check that with the people upstairs? And if it does get appealed, it goes to an appellate court, which in the federal system are called circuit courts. And those circuit courts will evaluate the decision made at the lower court or the district court and make a decision. You can, again, appeal after that, and that would be to the Supreme Court. Obviously, the Supreme Court has a very limited amount of time, and so most cases that are appealed are not allowed to go up to the Supreme Court. There's a process for that. So we looked at the appellate cases, which is those Supreme Court cases that dealt with this issue, and all of the circuit court cases, and there were about 260 of them. The reason we didn't look at the district court cases, number one, is there's a huge number. It's more like 2,000, and also a lot of them are not really that important from a kind of what we call jurisprudential point of view, from a legal point of view. So we limit ourselves at 260. Is still a heck of a lot of cases, and it is the entirety of the case law that really forms the Howey backbone of the Howey test.
Okay, and how did you conclude that basically fungible crypto assets are not securities? I mean, that's a pretty big statement, as you probably know. And this is according to case law. You're saying, according to the Supreme Court's definition, you don't believe they are investment contracts and they're not securities. So take me through the argument briefly, Lewis, if you don't
Well,
mind.
so it's important to say, in fact, there's very few things in life that are 100% of everything, right? And so, you can find an exception in a principles-based test. You can find exceptions to almost anything. What we're looking at is the bulk of tokens, certainly the bulk of tokens that make up kind of the coin market cap 100 for the most part, and the tokens that most people use. You've enumerated any number of them, but I'll talk about where exceptions can and frankly do arise. Um, the reason, though, which is your crucial question, is, well, you have to ask yourself, well, why is something a security in the first place, right? How do you get to be a security? Before you can say something is not a security, you got to say, well, what is a security? And what is a security is either something that is clearly enumerated and holds itself out as a security. It's kind of got a T-shirt that says security on it. So that's a share of stock, a bond, a note, something that anybody could pick up, take a look at, metaphorically speaking, and say, oh, that's the security over there. So that's easy enough. As I said, and that's why I gave the quick intro, we have this catch-all category of investment contract, and those don't have T-shirts on them. Nobody has an arrangement which they call, "Hey, I'm an investment contract," and so you have to look at the economic reality of the situation of what's going on. What the case law work that we did, the review that we revealed, is what we suspected is the vast majority of those cases applied to fundraising transactions in which one person gave capital to another person with an expectation of return based on that other person's efforts. And as many who are listening probably understand, the Howey test is set out in the Supreme Court in a famous case called SEC versus W.J. Howey and Company. The reason it's called the Howey test is because that was the first place that somebody set out a definition of what exactly an investment contract is. It's an investment of money in a common enterprise where there's a reasonable expectation of profit from the efforts of others. And where those four elements are present, the courts will find, yes, even though nobody called what they were doing a securities transaction, it had the effect of that. And so when we look at tokens, it's critical that you separate out two things. The fundraising. So Kathy, if I say to you, I've got a new token, I've got the NY Crypto Lawyer token. It's amazing. I minted only 10 million. That's it. Only 10 million. I'm going to give you the chance to get 1 million, 10% for only $100,000. And with that money, I'm going to go promote this thing. It's going to take over the world. It's going to be incredible. Within a year, you're going to have at least 10x your money, minimum. What I just did was pitch you an investment contract, right? I asked you for capital, $100,000. We're both in this together. I'm minting the token and promoting the token. And you have an expectation of profit. You're expecting to 10x your money at least within a year. Those are the elements of the Howey test. That arrangement, that scheme is an investment contract. And if I offered it more generally to the public, I'd have to register that with the SEC. Am I frozen? No?
I see. I can hear you fine, but I think your picture's frozen. So
yeah, it's weird. It sort of freezes periodically, and now it's not. In any event, so I just pitched you an investment scheme involving a token. However, let's say it wasn't a token I pitched you. Let's say I pitched you a new sneaker. It's the NY Crypto Lawyer sneaker. And this sneaker is not just something you can wear. It'll write your contracts for you as well. It's incredible. It's got like a chip in it. And I'm going to give you, I'm only going to make 1 million of these, and I'm going to let you buy, I'm only going to make 10 million. I'm going to let you buy 1 million for $100,000. It's irrelevant whether it was a token, a sneaker, an orange, or whatever it is. What's relevant from a legal point of view, and this is what the case law research reveals, what's relevant is the transaction a fundraising transaction? Is somebody running around saying, hey, give me money or value, crypto, something of value, and I'm going to give you something that you don't really want to use or consume. I'm going to give you something that's going to appreciate in price. And I'm going to be the one who's going to drive that price appreciation. That arrangement is that scheme is an investment scheme. However, the point of our article is when you look at the token itself, it has none of the hallmarks of a security. It's really a number. And we spend a lot of time in the article explaining what exactly is a fungible token. And it's really just a number that allows you to control a given instruction to a network of computers. Whatever that is, whether it's valuable or invaluable, not valuable or highly valuable, it's not a security. And so we distinguish, and this is really the critical point, the scheme in which someone goes and raises money from the object of that scheme, whatever that object may be. And over the course of time, and when you review the annexes to our article, and I encourage anybody to do so, I think you may have provided a link to the article, but it's for free, it's out there, anybody can review it, and you can review every single case. And there are cases that involved obvious things like real estate. Hey, would you like this piece of real estate? I'm going to drive up its value. You're going to make a lot of money. That's an easy case. There's cases involving whiskey aging in barrels. Hey, I don't know if you like whiskey, but buy a full cask of whiskey and 10 years from now, it's going to be worth a heck of a lot, and I'll make sure it is. There are cases involving earthworms, of animals being grown for their pelts, all kinds of things. Crypto tokens are just one more of those objects. And as the objects, as the whiskey and the earthworms, the animals and the pelts, the real estate, none of those things are themselves securities. Neither are the tokens, even though they're widely traded in secondary markets.
Right. So the investment contract itself could be different than the token itself. But what you're saying is the fungible token is in and of itself, according to case law, not right now a security.
In most cases. Now, you could obviously you could mess that up. You could imbue a promise and associate that promise with the token. And so the token becomes a representation of a legal obligation. If you did that, if you said you published on your website, you say, if you buy this token from me, I promise to you to pay you money or to do something, that's clearly a financial promise. Well, that's different. Now now we've changed the facts here. And there are some tokens that behave that way, where they really are a corporate promise to pay money. That's different. Most tokens are not like that. The vast majority are not like that. When you buy an Ether token, the Ethereum Foundation doesn't promise anything to you. If the Ethereum network stops working the way you had hoped it worked, you don't go to for recourse to any particular company or business. It just, the tool you bought doesn't work the way you'd hoped it worked. So really the question is there a legal relationship between the owner of the token and some other person? And if there is not, that really is the hallmark, or what we call in the paper, the intellectual element or modality of the security.
Right. And I want to talk about Ether in a moment, but just going back to what you just summarized here, Louis, the obvious question is, if you are right about these fungible assets not necessarily being securities, what does this mean for the SEC's chances of, prevailing on all these cases where, they've made this big push, said that most tokens are securities. And a lot of people former SEC officials, some people in the crypto world do agree with them. Then there's the other side that, strongly disagrees with them. But if you are right, what does this mean for the SEC's chances of prevailing on its cases?
Well, let's be clear, Kathy, that the vast majority of the cases that the SEC has brought do not reflect the question we just discussed. The vast majority of the cases that the SEC has brought had to do with fundraising transactions. So two of the most notable of those cases are Telegram and Kik, also Library, which you mentioned. In all of those cases, they involved a company fundraising by selling the token to others. And what the SEC has, I would say, quite appropriately argued is, hang on a second, guys. Those fundraising transactions, those were transactions that you made, you offered that to the general public. You didn't register with us the way you should. You didn't provide the information you were supposed to provide. You violated the securities laws. Fair enough. We'd agree completely. The vast majority. The only places where you start to see your question becoming very relevant are in cases like the one that the SEC brought against an individual who is allegedly, when he was an employee of Coinbase, had access to information that was not yet public about when particular tokens would become available in their marketplace. And rather than keeping that private, which he had, it's alleged, had agreed to do contractually as part of the terms of his employment, he unfortunately chose the path, the wrong path. And again, as alleged, he told his brother and his friend, hey, go buy XYZ token. 2 days from now, it's going to become available in the marketplace and it'll go up in price. And he did it something like 27 times. The SEC looked at that and said, well, at least 9 of the times that he did that, the tokens themselves were securities. And that's where we start to get into the issue, Kathy, is what about those transactions? Mr. Wahi was not raising money. Mr. Wahi had no relationship with any of the projects. He was just a guy who was trying to take advantage of something, and if the allegations are correct, wrongfully so. He is separately from the problems he has with the SEC. The Department of Justice has brought criminal charges against him for wire fraud. So the SEC is really lobbed in here on a different question, not were somebody's fundraising transactions invalid. The SEC is asking was when somebody interacted with a token, should that person have known that they were interacting with a security? And we would say no, he had no reasonable basis for knowing that his transactions were securities transactions. They were wrongful. They were just not securities transactions. And that becomes critical when you think about how tokens work, because in order for tokens to work, they have to trade freely. And if tokens are securities, they will not be able to trade freely as a practical matter.
Right. And thank you for clarifying that. So the majority of cases are not, majority of cases right now being waged by the SEC do not deal with this question that you're talking about because they do deal with fundraising. There's a lot of gray area out there. One thing I found interesting about your paper, there's this idea out there that some crypto assets could initially be securities, but then become decentralized enough that they no longer qualify as a security. Former SEC official William Hinman said this was a case basically with Ethereum in a 2018 speech that's gotten quite a lot of attention and has been, cited in many cases, including the Ripple case. You've argued that current law doesn't support the idea that something that's a security can morph into a non-security. Can you talk a little bit about that? Because I think that's also very important, and that's that idea hasn't been discussed enough. So why can't something initially be a security, then morph into a non-security, according to case law?
Sure. Well, it is a completely anomalous concept for the law as it works today. There's just simply no such thing as a asset that was a security and then stops being a security based on events that are extrinsic to that asset. So it just does not exist. It's a completely made up idea. Not to say that people shouldn't be making up new ideas, only to say that there's no basis. And to the best of my knowledge, the SEC has not cited any case law precedent for saying, well, we see in this case X, something wasn't a security or was a security, and then it stopped being a security. So the first and foremost point is that it's a new theory, and it's fine to bring up new theories. Nothing against that, but it's just that it's difficult to charge people with violations of the law based on something that has no support currently in the law. So that's
win
kind
a case, and then that could be precedent, right?
Absolutely, yes. Separately in the paper, we argue it would be a bad idea. So yes, but we completely recognize and support that there's nothing wrong with the SEC bringing up new ideas and new solutions. The problem, Kathy, with that idea, this morphing idea, right, is that if something can morph out of being a security, then in theory it can morph back in, right? So here's an example. There's a project team and they are really driving the bus. Everybody understands that it's these 5 people. And if it weren't for them, this asset would have no value whatsoever. They're brilliant. They went to Stanford. One went to MIT. My goodness, how clever are these people? And thank goodness, because I own a lot of their asset. And if they stopped, I'd be really sunk. But unfortunately, that team made the mistake of taking a charter plane over the Pacific to go to a conference in Singapore. And really, unfortunately, the plane went down in bad weather and the plane was lost. As far as we know, there were no survivors. I guess, besides feeling horrible for the loss, the token's not a security anymore because the people who ostensibly were driving it forward are gone. So I guess one outcome is that you can now start trading the token, not in a securities way because, well, that's what happened, right? But it turns out one of the people, this lady, she grabbed a hold of piece of a wing, and she floated in the sea for like a week, and she landed on an island. And nobody knew. And then 6 months later, she was rescued. And she was the one with the noggin. And she comes back, and it was just a harrowing experience.
Then it becomes a security again.
It becomes a security again? And of course, that's a very deliberately outlandish circumstance, but there are many other circumstances that are much less outlandish. Somebody leaves the project, they come back, and this happens all the time. There's an argument among the founders. There's all kinds of things happen. Somebody has a new idea. There are factors that cannot be known by people in the marketplace. And it is unrealistic and impracticable to expect that market participants are going to monitor what is going on at any given time to see, did they stop the scheme? Did they finish the scheme? Did they start it up again? It's a ridiculous kind of idea when you get to thinking about it, especially when there are better ways of addressing the legitimate concern. And so, because I know we're probably running close to time here, but one of the best ways of addressing that is found in one of the bills that was entered into Congress last year by Senators Cynthia Lummis and Kirsten Gillibrand of Wyoming and New York, respectively. And in their bill, what they would do is rather than treat the tokens as securities, they would say to the project team, look, if you have an outsized impact on a project with a token that's trading publicly, you've got to disclose what you're doing and how you're doing it with tailored disclosures that are focused on the kinds of things that the market would care about. And that would address the concerns, I would argue, that the SEC legitimately has without putting market participants in the wholly impractical position of trying to figure out whether and when a given token morphed or unmorphed at any given time.
Right. And it is difficult, Louis, just thinking about it from the typical crypto holder, crypto enthusiast's point of view. I mean, how would they have any idea at which point something is a security under current laws, but if it's able to morph into a security, morph back, how would anyone know that or keep up with it? So you talked about, there's so many cases out there right now dealing with the SEC, with whether crypto assets or securities. You talked about one important one to watch, Coinbase. Okay.
Yep.
What are some of the other important developments or cases that you are looking out for that could set a precedent in the industry and kind of change the way the industry views security or a non-security? What are you looking
Absolutely. And just for your viewers, Kathy, although the case did very much involve Coinbase, they were not a party to the case. So it's the SEC versus a gentleman named Ishan Wahi. So you worked at Coinbase. So you're not wrong. I just don't want to give the impression Coinbase is not litigating that case. So I just want to clarify.
Thank you for clarifying. It's employees and
yes, exactly.
acquaintances of the employees, former employees.
Exactly. That's exactly right. I think there are a couple of cases out there that are going to be very important for different reasons. One is one you mentioned earlier, Kathy, which is probably the case that the crypto community is most focused on, right? And that is SEC versus Ripple Labs. What makes that case so interesting is that it has absolutely nothing to do with whether or not tokens are securities. Ripple Labs raised money, huge amount of money, like $50 billion, right, by selling XRP tokens. That's down the middle, the kind of activity that at least potentially would be investment contract activity. However, both of the parties, the SEC on the one hand and Ripple Labs on the other hand, have attempted to make the case focus on the status of the XRP token for their own separate sort of strategic reasons. At this point, the case has been going on, I think, over 2 years. Well over 2 years, and we are expecting some decision on the motions for summary judgment, which is the point before you have an actual trial. So you've done all your discovery, everybody's known and figured out whatever there is to know and entered whatever evidence there is to enter. And at this point, it's up to the judge to make a decision, and she can do one of three things. She can grant the motion for summary judgment for either the SEC or for Ripple Labs. So those are two options. Or she can deny them for everybody, for both of them. So she can grant them for one and not the other and not the one, or deny them completely. If she grants them for either, grants the motion for summary judgment for either the SEC or for Ripple Labs, it is exceedingly likely that whoever lost is going to appeal, as I explained, and go up. In the case of Ripple Labs, the case is in the Southern District of New York, which is the most common case to bring securities actions for various reasons, and they would appeal it to the Second Circuit, so which is probably one of the leading circuits in the U.S., and would get appealed. That could easily be another couple of years. But the decision that Judge Torres, the judge in the Southern District, writes will shape people's thinking on this, even though the status of the XRP token is not directly relevant, because both parties have kind of put it into play. If she makes a decision, she will likely comment on it. There's a third option in which she denies the summary judgment motions from both sides and wants to go to trial. And that's definitely possible. It's become such a hot potato issue, she may conclude that she really wants to do more fact-finding in a trial and really give people an opportunity to sort of engage in that process. So we may or may not see that. But that case is going to...
Oh, I'm sorry. So just to clarify, though, you mentioned the XRP token is not directly related, but both parties have brought it up. So whatever the judge says in this case, whether, she deems that it was a securities or it was not, that could ripple through to the industry, not to be cutesy about words, but that could ripple through to the industry in terms of setting a precedent and being used for other cases. Is that correct?
It's broadly correct. We have a term in the law that applies here, and that term is a Latin term called dicta, D-I-C-T-A, which is something that is said. And in the law, what that means is when judges write opinions, they use a lot of words. Sometimes these opinions can go on for 30, 50 pages. And not everything that the judge writes goes directly to the question that is presented to the judge. They just have lots of things to say, typically. And the things that the judge says that don't go directly to the fundamental question are called dicta. That is technically not precedential because it does not go to the immediate question at hand. Anything Judge Torres says about the XRP token technically would be dicta because the case is not about the status of the XRP token. However, you're certainly correct that people will look to that as the first really fully litigated case where a federal judge may or may not, depending on what she chooses to say, have strong statements. For example, if she says, I'm convinced, the SEC has convinced me, the XRP token is a security and they violated the securities laws, that's going to go, that's going to be a big deal for sure. Even if technically it's not technically precedent, it's going to go a long way. Likewise, if she says, I don't think the XRP token is a security, I think that's ridiculous, it won't be precedent either, but it'll carry a lot of weight. So it's a little bit of a nuanced point.
Okay. Well, let me end with one last question for you. One complaint that the crypto industry, those in the crypto industry have had is that they feel like after years of not getting guidance on this issue about what's a security or what's not, they feel that regulators have stayed mum, and then all of a sudden there's this rash of cases, right? The SEC's viewpoint is the opposite, that they feel it's been very clear from the beginning that fundraising equals securities, and that these companies should have come in, talked to them, and said, listen, look at what we're doing. If this is a gray area, tell us if this is legal. So from your review of case law and just your position in the industry, where do you stand? Has the law been clear about what is a securities or what's not?
Yeah, I think as we said, most of the cases to date have dealt with fundraising, and it's fair to say the law is reasonably clear. It's not totally unclear.
About
However,
fundraising.
about fundraising, exactly. However, looking at all 260 cases, many of them were overturned when they went to appeal. Many times people asserted that the arrangement was an investment contract and the court disagreed. So, without having anything to do with the digital asset cases, the law is not like crystal clear. Like, people struggled with this law. One of the other annexes to our paper is a list of scholarly articles on this topic. And long before digital assets came along, there were like at least 50, maybe 100 scholarly articles where people were kind of confused before anything to do with digital assets. So it's important to say, when we say the law was clear before, it was sort of clear in a way that everybody was still kind of confused. Digital assets sort of made it worse. But I think the SEC's main point is people should accept our position. And to some extent, that's fair. But I think there's so much at stake here. People are saying, and the SEC, exactly as you said, has really not been clear. In 2019, the staff of the SEC released ostensible guidance, but it wasn't from the commissioners itself. It was sort of staff guidance. And it didn't really give anybody a particular roadmap. It just listed out factors that the staff thought were relevant, and it didn't tell you how to weigh them up. So you kind of didn't really know. And then since that 2019 guidance, it appears under Chair Gensler that that's no longer particularly relevant. It's never cited anymore. It's still up on the SEC website, but it's not cited. It's not referred to. Nobody talks about it. So one of the things that causes consternation to people trying to comply with the law is, well, is that relevant? Is it no longer relevant? What are we supposed to do here? So I think there's some blame to go around on all sides, to be diplomatic at the end here, Kathy. I think many in the industry have sort of been willfully blind to some of the case law that we show in the article and really haven't been intellectually as honest as they could be. But on the other hand, the regulators have not made it very easy for people. And I think they could certainly do more. And I think one of the commissioners, Commissioner Hester Peirce, has criticized her fellow colleagues for not being more clear along the way. And she has proposed a safe harbor that would provide more guidance and other steps. And I think, if I had to weigh it out, I think a better job could be done in terms of giving more guidance on the part of the SEC, even if some of the crypto community can be a bit whingy, But I think we'll get there eventually, but it's a bit of a bumpy path. But I love talking about this stuff, and thank you for having me on the show.
Yeah, thank you so much, Louis. You can follow Louis Cohen at NY Crypto Lawyer on Twitter. You can find his firm there and his research. That's it for this edition of Crypto Defined. We'll have a written recap of Louis's interview in the next few days on truthdao.news. Thank you so much, Louis.